As you may know, you may already be aware about the rules of what we do here is just making your oral presentations and responding to some questions that I may put to you from either your discussions or your submissions about what I find intricate. And each team will have a minimum of 20 minutes, and it's upon you to tell us how you'd want to break that down. But before I go into that, just want to confirm whether we have the applicants with us. Can you confirm that?
Yes, sir. The applicants are present.
Yes, okay, just a moment. Yes, so the applicants are with.
Yes, the applicants are present.
Yes. All right. Well.
The applicants are present.
That is good enough then. Thank you. And then the respondents.
Yes, sir. The respondents are present.
Yes. So the respondents, I can see you're in different locations at the moment.
Yes.
All right.
Yes, Chairman.
So what will happen? You will keep your cameras on, and but you keep your microphones muted unless you're invited to speak. So you have to keep your microphones muted. I'll also try to keep mine on if the network permits, but if I see it breaking, then I may put mine off so I can give you enough bandwidth to submit without any interruptions. Yes, so like I say, just reiterate, 20 minutes. You may break them down the way you want. Whether you want to, that's if you want to do the rebuttal. So you may say speaker one will say, take this minutes, speaker two, and then we'll have these many minutes for the rebuttal. So I'll now give the floor to the applicants, and let's hear what they have to say. And applicants, your time starts to run now.
With profound respect to this arbitration panel, Josephine Ekwemuka is my name, and appearing with me is Ridwan Busayo, and together we announce our appearances as counsels to the appellants in this instant case. For the purpose of this oral proceeding, I shall be handling issue one for a period of 8 minutes, while my co-counsel will be handling issue 2, as well as our prayers for a period of 7 minutes, and we have reserved 5 minutes for our rebuttals. Thank you very much, Mr. Arbitrator. Proceeding with our submission. Arbitrator, may I confirm if I should expect the respondent to make their appearance or proceed with my argument?
No, proceed. They'll introduce themselves when they get the chance.
Thank you very much, Mr. Arbitrator. Proceeding with my submission, I shall begin to give a brief summary of the facts before this panel. The fact is that Kaid Zamani was transferred from FC Eco to Club Brugge for a sum of 500,000 euros. However, Club Brugge in turn obtained a waiver from Silverbird FC and Lekki FC. A waiver which would then stop the payment of training compensation. However, along the line, it was required for our clients to then pay Silverbird FC and Lekki FC a training compensation in the tune of 150,000 euros from a FIFA collection of allocation statement that was released. And we are before this panel to contest this position. It is on this premise that we have couched 2 issues for determination before this panel. The first, which raises the question of whether or not Club Brugge's failure to upload the waiver documents during the electronic player passport process affects the validity and enforceability of waived rights. Mr. Arbitrator, for our second issue, we have couched that whether or not Lekki FC's team captains signing the waiver is valid in law. Proceeding with our submission, Mr. Arbitrator, On the first issue, I have streamlined my argument into 3 main standpoints in order to guide my submission. The first, which lays the foundation for training compensation. The second, which refers to conditions for a valid waiver and whether or not our clients have complied with them. And the third, which is the reasons as to why our clients failed to upload the waivers. Proceeding with my submission, it is our vehement contention that Club Bridge's failure to upload the waiver documents during the electronic player passport process does not affect the validity and enforceability of waived rights. Mr. Arbitrator, in the case of Mutu and Pen in the European Court of Human Rights, it encapsulated the concept of contractual freedom in any transaction relating to player transfer as well as training compensation. In the case of Article 20 of the
Counsel, you're citing
yes,
for me. You're citing for me a case from the European Court of Human Rights. What should I do with it? Is it binding on me?
Thank you very much, Mr. Arbitrator. A case from the European Court of Human Rights has been cited in this initial case because the merits of that case are similar to this one at hand. However, the effect is only persuasive on this court, on this panel. Proceeding with my submission, Mr. Arbitrator, by virtue of Article 20 of the Regulation on the Status and Transfer of Players, as well as Annex 4 of the Regulation on Status and Transfer of Players, which sets out the framework regarding the payment of training compensation. Mr. Arbitrator, also in the case of Dundee United FC versus Club Atletico Village Sarsfield, we see the importance of flexibility in agreements relating to player transfer and training compensation, and the panel stressed the importance of good faith, transparency, and fairness. Mr. Arbitrator, now on to the second part of my argument. The FIFA Dispute Resolution Council, in the FIFA GRC decision number 67516, in the case of FK Sarajevo versus KVC Westerly, highlighted 4 conditions that must be met before a waiver is deemed valid before the law. The first, being that the waiver is not contrary to law, public policy, and good morals. And the second, being that the waiver is made by a person who has the capacity and authority to do so. And the third, that the waiver is made clearly. The fourth, that the person renouncing the waiver has a right to renunciation. Mr. Arbitrator, by virtue of paragraph 4 of the moot problem, we see that our client Club Bridge obtained a waiver from Silverbird FC through an official correspondence on the TMS and from Lekki FC through an agent of the club. All of these have then complied with the first 3 conditions as highlighted in the case of FK Sarajevo versus KVC Westerly. As for the 4th conditions, both Silverbird FC and Lekki FC are initially entitled to training compensation. That is, this right is present. Therefore, they do indeed have the right to renunciation. Mr. Arbitrator, having complied with these conditions, the appellant submits that there are no legal obstacles to the validity of the waivers. Moving on to the third leg of our argument. We are not unaware.
A moment.
Yes,
so your clients, have they had a chance to look at the FIFA clearinghouse rules?
Yes, they have, Mr. Arbitrator.
Have they also had a chance to look at the terms and conditions of the FIFA clearinghouse?
Yes, Mr. Arbitrator, indeed they have.
Do those set of instruments require waivers to be uploaded while doing the settlement of a payment?
Mr. Arbitrator, I'm sorry, can you rephrase your question?
You said your clients have had a look at the FIFA clearinghouse rules and the terms and conditions of the FIFA clearinghouse. So I'm asking, do those 2 instruments make it an obligation or a duty for someone claiming to benefit from a waiver to upload a waiver while entering a settlement?
Yes, Mr. Arbitrator, they indeed have an obligation. However, we contend that the waiver obtained from Silverbird FC and Lekki FC is still enforceable. Mr. Arbitrator, my clients also...
Slowly, so if they have that duty, did they do the uploads? Did your clients do the uploads?
Thank you very much, Mr. Arbitrator.
So you're saying they did not upload the waivers?
Yes, Mr. Arbitrator.
Is that your position?
Yes, but we have good reasons as to why they failed to upload the waivers, Mr. Arbitrator.
Let's go slow. So if they have a duty to upload and they fail to upload, could we say that they acted irregularly or recklessly or unresponsibly?
Thank you very much, Mr. Arbitrator. The failure to upload was due to no intentional fault of our clients. Our client's host country at the time was currently going through natural disasters, which prevented our clients from uploading the waivers. Our client's host country is Belgium, and at the time, Belgium was currently going through a severe flood, which interrupted power supply and led to network outages. Mr. Arbitrator, may I confirm that you can still hear me? Please, may I confirm that I can still be heard by the other team or anyone else on the call?
I can see and hear you.
All right. Thank you very much, Mr. Arbitrator. Proceeding with my submission, Mr. Arbitrator.
You're saying that there was a flood?
Yes, Mr. Arbitrator.
Do we have any evidence on the record to prove that?
Yes, Mr. Arbitrator. The flood that occurred in Belgium occurred from the beginning of January 2024 to ending of February, and this coincides with the time duration that is stipulated for this initial fact, Mr. Arbitrator.
So, Counsel, are you becoming a witness now? Are you giving evidence at the bar? So are you becoming a witness?
My Lord, Mr. Arbitrator, that is not my intention. However, the flood in this instant case indeed affected my client's ability to upload this waiver. We are not denying that we have an obligation to. However, we are before this court with concrete reasons for why we failed to upload the waivers, Mr. Arbitrator.
But you're becoming the one giving us this evidence.
Mr. Arbitrator, the flood in this instant case was something that no one could expect at the time, and it incapacitated.
Yes, I didn't say that anyone could expect it, but are you the one supposed to be telling us this or another witness?
Mr. Arbitrator, this is included in our brief as well. The flood, the natural disaster, it is included in our brief, and by the rules of these competitions, we are allowed to impute facts that are in relation to real life situation at the time.
All right, proceed to the next issue.
Thank you so much, Mr. Arbitrator. By virtue of Article 10, Paragraph 5 of the FIFA Clearinghouse Regulations, we see that a proceeding before the CAS has a timely appeal filed for the Court of Arbitration of Sports has the effect to suspend the EPP, that is the Electronic Player Passport, and the corresponding allocation statement for the durations of the proceedings before the Court of Arbitration for Sports. This implies that the waiver can still be uploaded during the course of these proceedings and would offer the same effect like it would if it was uploaded earlier. Mr. Arbitrator, it would only be an attempt to gain undue advantage against the principle of uberime fede for the respondent to then receive a waiver receive a training compensation after signing a waiver. Mr. Arbitrator, by virtue of paragraph 8, line 1 to 3 of the motion, we see that Silverbird FC was overjoyed to receive a training compensation after signing a waiver. Mr. Arbitrator, in the case of Rayo Vallecano versus Albacete Balompi, the panel stressed the importance of good faith in all transactions relating to player transfer as well as training compensation. If a minor procedural defect affects my client's rights,
Sorry, Epilance, I'm losing you a bit. Okay.
and confers an unjust. Apologies, Mr. Arbitrator. May I confirm that I can still be here? We had a minor network setback.
Now I can hear you. You can just make that point again.
Thank you very much, Mr. Arbitrator. Mr. Arbitrator, we submit on the first issue that Club British failure to upload the waiver documents during the EPP process does not affect the validity and enforceability of waived rights, and we pray this court to hold so. Mr. Arbitrator, my co-counsel Ridwan Busayo would then address this court as we issue too.
As he comes in, I want also to be addressed on the issue of why you're before CAS. Why are you before CAS Are there any other available remedies before you come to this court or arbitral tribunal? Are there any other remedies?
Mr. Arbitrator, may I proceed?
You may proceed, but I want a response to that question.
Yes, Mr. Arbitrator. There are other remedies which includes an alternative dispute resolution. And for first and foremost, before a case can be instituted by the Court of Arbitration for Sports in this instance case, as we have rightly done, this case, we brought this case as a result of an appeal against the decision of the FIFA General Secretariat. Of course, we are not contending that there are no other resolutions in this instance case, which includes the arbitration out of court settlements, in which is called alternative dispute resolution. Thank you very much.
So why didn't you consider those
further
options?
questions from people?
Why didn't you consider those other options? The options internally at FIFA, the appellate options at FIFA, why didn't you consider those before coming here?
Mr. Arbitrator, thank you very much. The reason why we are before this honorable panel is because the Court of Arbitration for Sports can also serve as an arbitral proceeding for out-of-court settlements. In this instance, in which we are having, the Court of Arbitration for Sports can be put on the same level, on the same facts with an alternative dispute resolution, in as much as it is not a litigation and it is not before a court. And this can be seen pursuant to Article 10 of the FIFA Clearinghouse Regulations. Article 10 of the FIFA Clearinghouse Regulations.
What does it say?
Which clearly says that an appeal of any FIFA decision goes definitely to the Court of Arbitration for Sport. And in this instance case, we are appealing the decision of the FIFA General Secretariat, in which gives us a credence and a very validity to bring this case before this honorable panel. And this can be clearly seen pursuant to Article 10 of the FIFA Clearinghouse Regulations, which provides that any decision of the FIFA General Secretariat or its executives will be brought directly to the Court of Arbitration for Sports. And this can be seen in the case of FC Boca Juniors case, which has been duly submitted in our memorials.
Very well.
Without any question, if there are no further questions from the panel, I should like to proceed with my argument. May I proceed?
Proceed.
Mr. Arbitrator.
Proceed.
Thank you very much. Thank you very much, Mr. Arbitrator. Once again, I am RB Abdugani, and I shall be making submissions on the appellant issue 2, which borders on whether or not the waiver signed by Leggy football team captain is valid in law. To guide this argument, I have stratified my presentations into 3 key sections in order for members of the panel to have a free and understanding flow with me. This part of my argument lays a succinct foundation to waiver and its validity. The second part explains the role of a football team captain, while the third and the last part of my presentation explains how players are employees of the club and how they can act in representative capacity on behalf of the club. Proceeding on the first part of my presentation on waiver and its validity, it is clear without doubt that a waiver occurs when a party loses all possibility to claim training compensation. And as such, the jurisprudence of the FIFA Clearinghouse Regulation also gives credence to the validity of a waiver that is signed by a club representative, especially when there is a clear intention by the club to renounce their rights. Mr. Arbitrator, it is pertinent to note at this point that waiver, as the subject matter of discussion, cannot be said to have existed without training compensation. And as such, the FIFA regulations on the status and transfer of players allows for training compensation to be waived through a valid waiver. The following has been given credence to by the Court of Arbitration for Sport in the case of FC Midtjylland against Club Atletico Vélez. Citations duly provided in our brief of memorial, where the panel in this case ruled that a club can waive its right to receive training compensation through a valid waiver, provided that there is clear intention of which is not proven to be fraudulent. Mr. Arbitrator, The decision in this case clearly supports Club Bruge's position that the waiver obtained from Lekki football team captain is valid in law. The question that begs for an answer before this panel is, does the role of a football team captain include signing waiver on behalf of the club? This, on the role of a football team captain, while many may think that the role of a football club team captain is limited to on-field activities, like taking care of pointers before kickoff, in order to determine the directions in which the team are to attack, or likewise for penalty shootouts, or even being the first person to receive trophies as the case may be. It is, however, pertinent to note that the role of a football club team captain goes far beyond this, as FIFA RSTP allows for delegation of authorities within the clubs. Mr. Arbitrator, on the third and the last part of my presentation, which talks about how players are employees of the club, it is imperative to note at this point that the principle of vicarious liability applies in this instant case, in which an employer is held responsible for the actions of their employee. And this has been settled as an established fact in the Locus Classicus case of Walker against Crystal Palace, where the panel ruled that footballers are employees of the club. The decision in this case was further re-echoed in the case of Eastern against Newcastle United, where the panel also ruled that footballers are indeed full-time employees of the club. Additionally, the Court of Arbitration for Sport referenced the jurisprudence of the FIFA Clearinghouse regulations, referenced the jurisprudence of the FIFA Dispute Resolution Chamber in the case of FK Sarajevo against KVC Westerlo, that documents that are signed by employees of the club have binding effects on the club, thereby placing the onus on the club entitled to receive training compensation to ensure that documents do not inadvertently waive their rights. So, the Dispute Resolution Chamber in this case.
So, Council,
Mr. Arbitrator,
you're saying the captain is an employee of the club. Fair enough. So does every employee have a right to bind a club? Let's say we have a janitor whose role is to clean the stadium, but they have an employment contract. Can that janitor bind the club? Because they're employees.
Of course, we are not saying it is all employees' action that can bind the club. However, Records should be making to this cause of arguments, particularly on the fact that the Lekki Football Club team captain we are talking about belongs to a lower category 4 clubs. And this is quite common in clubs like lower category 4 clubs as Lekki FC in this instance case. And as such, Mr.
So are you saying that the rules? Are you saying that the rules of employees binding the clubs are subject to the level of the club, in that if you're level 4, then the employees' actions are binding. If you're level 1, then they're not binding. Is that your submission?
Our submission generally on this is that it is not uncommon in lower category 4 clubs. And the case of CA Boca Juniors against
at this level, are we looking for, at this council, are we looking at whether it's common or not, or whether it's lawful or not? If someone
it is common in lower category 4 clubs.
If something being
and it is lawful,
so does something being common make it lawful?
Can you please come again, Mr. Arbitrator?
Does something being common make it lawful?
Of course, we are not saying something being common is lawful. However, Records should be taken in this particular case of Bologna FC against CA Boca Juniors, where it has been established that it's a common principle in lower category 4 clubs for club officials to delegate administrative responsibilities to senior players. And in this instant case, Lekki Football Club team captain is a senior player and is considered as a prominent figure in this club. Again, to the question asked by the panel, it is not for every employee to make a decision on behalf of the club. However, when an individual holds a prominent role in the club and they act in a representative capacity without objection from the club itself, their actions shall be binding on the club. And this can be seen in the case of Joseph Blatter against FIFA, in which citations have been duly provided in our brief of memorial. Thank you very much on that question, Mr. Arbitrator.
So, Council,
if there are no questions, I would like to submit on our.
From the jurisdiction of Lekki, which country is Lekki based in?
Come again, Mr. Arbitrator.
The club, the sailing club, which country is it based in?
Nigeria. Nigeria.
Based in
Nigerian
Nigeria.
Football Federation, Mr. Arbitrator.
Yes, so if it's
Yes.
based in Nigeria, how are clubs in Nigeria incorporated? What corporate structure do they take?
Mr. Arbitrator, on this question, the clubs in Nigeria are categorized. Normally, there are 4 categories of club, and it is only club in the EU and the CONMEBOL that are involved in category 1 club. And of course, in this
I am asking what corporate category in Nigeria do clubs take? What is the corporate? You know about corporate personality? You know about corporate personality?
The companies are, Mr. Arbitrator?
So they are companies. Are you saying
Yes,
that they are
Mr.
companies?
Arbitrators.
Yes. Now, in the law,
No,
slowly. So, in the law of Nigeria, who has the power to bind the company? Who has the power,
to bind
the
Mr.
company?
Arbitrator?
Yes, who has the power to bind a company in Nigeria?
The power to bind the company belongs on the board of directors in the particular company.
Yes. So is the captain sitting on the board of directors?
Thank you very much on this question, Mr. Arbitrator. First of all, after we've established that the club football captain is an employee of the club, recourse will be taken to the FK Sarajevo's case, where the FIFA Disputes Resolution Chamber made mention on this. On this, I shall be making recourse to my submissions on the fact that the principle of vicarious liability applies in this instance case. And of course, the employee of the club cannot be put on the same.
My question is simple. We've come to a conclusion that in the jurisdiction of the sailing club, only directors bind companies. So my question is the captain a director of the company that forms the corporate body running the club? That is my question. Say yes or no.
No, the captain is not part of the board of directors of the particular case. However, in this instance, the captain is an employee of the employer. And that is why we are submitting on this instance that the principle of vicarious liability I proceed, Mr. Arbitrator.
Okay, summarize in 1 minute. Summarize in 1 minute.
Mr. Arbitrator, can anyone hear me?
Yes, I can hear you, and I'm saying summarize in 1 minute.
Oh, thank you very much. Therefore, in this instance case, we are contending that it is the representative capacity of Lekki Football Club team captain that makes him competent to assign to the waiver on behalf of the club, considering the circumstance in this case. The circumstance in this case can be testified from the moot facts, particularly paragraph 4, line 7 to 8, which shows that our clients took necessary steps to contact Lekki Football Club, which can be seen from the wordings of the moot facts unable to reach them. And in this instance, we are contending that the club which took necessary steps and commitment to ensure that the appropriate quarters were contacted. And the decision to contact Lekki football team captain was not one that was born out of disrespect to hierarchy, but one that was necessitated pursuant to the particular circumstance on that case. And it's on this note we are submitting on the oath that the waiver that was signed by Lekki football club team captain is valid in law. Without further questions from the panel,
I thank you to our applicants. So we'll now hear from.
I seek the leave of this honorable panel to proceed with our prayers on the whole on this issue.
We will find the prayers in your submissions. So let us listen in from the respondents as to what they have to share with this court on the matter. Respondent, your time starts now. Respondents, I can see you're still muted, but your time starts now. Respondents, can you hear us? University of Abuja?
Respondents, please, can you hear us?
Yes, apologies. I think we're having a network issue. My colleague is having a network issue too. However, I pray this court that it permit us, my teammate, to settle his technical issue.
Okay, I'll give you a minute to just settle that technical issue. And
Thank you very
as you sort it out, so you can probably give him a call to sort it out. The applicants, please keep your camera on.
Thank you very much, Chairman.
Applicants, please turn your camera on. Yes, just keep your mic off, but leave your camera on. So I want to see how you react as the others share with us.
Apologies, Mr. Arbitrator. We didn't get the last part of your.
Just keep your camera on. Just keep your camera on.
Oh, thank you, Mr.
The respondents, can you first try putting your mics on and then put your videos off? Just try put your mic on, but put your video off.
Well, Mr. Arbitrator, while I wait on my colleague to settle the technical issue, my name is Idiska Ayeni, and with me is my co-counsel, David Ihezo, and we'll be representing the respondents in this case. I'll be basing it on 4 basic merits. I'll be taking merit 3 and 4. Mr. Arbitrator, I want you to take notice if you can hear me.
I can hear you, and you may proceed.
Thank you very much. So proceeding, I'll be taking merit 3, that the captain of Lekki FC has no legal authority to sign a player. Council holds that the waiver is void ab initio, as Club Brugge erred in the way and manner of obtaining TC waivers based on the following argument. 1, that there was no consideration to be furnished as it is applicable in common law jurisdiction, which Nigeria is part of. Secondly, that the captain lacks the legal capacity to go into any contract with Brugge KV. Why? For us to understand the legal capacity of the captain to be able to go into a contract, we must examine the role of a captain. There is no clear definition of who a captain is. However, Rule 3, Paragraph 10 of the Laws of the Game 2020 provides characteristics and roles that are being played by a captain of the team. These include that each team, which states, and I quote, each team must have a captain on the field of play who wears an identifying armband. The team captain has no special status or privileges, but has a degree of ability for the behavior of the team. Thus, this a phrase stands out in the definition.
Answer a moment. A moment.
Yes.
The IFAB rules, do they apply off the pitch?
Sir,
if we are off the field of play, can we cite the IFAB rules?
The IFAB rules apply to the play in the pitch. However, it could also extend persuasively and binding out of the pitch. Did I answer that, Mr. Arbitrator?
Okay, yes, proceed.
Thank you very much. Thus, the phrase stands out that the captain has no special status or privilege, highlighting that the captain is just a mere player like every other player. Now, 6, the definition. Who is a football player? Now, 6, the definition. Who is a football player? According to the RSTP rule, a player could either be an amateur or professional. In the instant case, the football captain is a professional. And according to Article 2 of the RSTP, it defines a professional as a player who has a written contract with a club and is paid more for his footballing activity. Thus, the term footballing activity, it has not clearly been defined by FIFA statutes or rule. However, we wish to borrow the definition from the English jurisdiction, which is also applicable in Nigeria as a common law jurisdiction, which states in Form 15 of the Premier League, which states that a professional footballer has the responsibility to attend and participate in matches, play to the best of their skill, maintain physical fitness, among other roles, which never at any point mention the legal representation of the player for the club of the pitch. Thus, it should be noted that the role of the captain is mere customary and starts and ends on the pitch. These responsibilities, as outlined by the appellant, include armband, communication with officials during the match, representation of club in official ceremony, and it ends there. Going further, we would like to look at Article 718 of the Swiss Code, which binds FIFA and its associates. It states that persons who can represent an organization must include directors or delegates expressly authorized to represent. Mr. Arbitrator, take notice that the delegate must be expressly authorized. At no time was the captain of Leggy FC expressly authorized by the board of directors to take on this. Further, Article 32 of the Swiss Code also provides for an alternative where a third party has gone into a contract for a club without its authorization. This comes if that club ratifies it after going into that agreement, which in this case, Lekki FC never at any point, based on the fact of the moot, ratified the decision of Lekki FC, which begs the question, on what authority or on whose authority does the Lekki FC captain based on? Furthermore, the only available alternative which the FC captain could actually represent the club is as an intermediary. Consequently, Article 3 of the regulations on working with intermediary provides that an intermediary must be registered as one in his association, as well as having an intermediary declaration, which based on the moot facts, the captain lacks any of it. the captain fails to meet the above requirements and thus his signature to the waiver is invalid. However, clearly stated FIFA statutes and regulations bars footballers as well as coaches to work as intermediaries in football agreements. Thus, the captain fails to meet the above requirements. We pray this court that the waiver hold no water and be disregarded, and the money due to be paid to Lekki FC by virtue of the allocation statement of 110,000 euros should be upheld. Are you there, Mr. Arbitrator?
Yes. So, counsel, here's my question. You
Yes.
cited common law.
Yes.
And common law includes doctrines of equity, isn't it?
Yes.
So we have a doctrine that says equity looks at what is done as that which ought to be done. And so from the facts, leaving aside that the captain did not, the captain may not have had the powers, from the facts that we have, didn't the clubs intend to sign off the waivers? What was the intention of the club? Didn't it involve signing off the waivers?
Well, according to the facts that we have, they intended, however, they haven't finalized their intention. What could be seen there could be stated as an invitation to treat rather than an offer.
The issue is invitation to treat?
Yes, it could be seen as an invitation to treat rather than an offer from Lekki FC.
Yes. What identifiers point it to being an invitation to treat?
The identifiers is stated in the fact which states that they had an idea of going into an agreement. However, the express statement of an offer would have to come from Lekki FC, expressly stating that they have waived their rights in paper and then signed by the board of directors of Lekki FC, which in this extant fact was not followed. Did I answer that?
All right, then.
Thank you very much, Mr. Arbitrator. Any more clarifications, Mr. Arbitrator?
No, if that's all, then we can go to your co-counsel.
Okay, moving further to my merit 4, that the club breached its contractual obligations and violated FIFA regulations by failing to upload training compensation waivers to TMS. Thus, the failure to meet procedural process has broader implications, and the contract is not binding based on the following. One, that the non-compliance with TMS requirements, Article 4.3 of the FIFA FTMS, mandates and put it as a requirement to upload data documents, including TC waivers, which Bruges failed to do. In this case, Bruges received multiple automated notifications to upload training compensation, however, failed to do so. And this is also contrary to FIFA Circular 1805, which outlines this expectation to further transparency in the process, stipulating players' regulations
No,
to
counsel.
be uploaded. Yes,
counsel,
arbitrator.
when from the law of contract,
Yes,
from a contract, a party accrues rights and obligation, isn't it?
yes.
Can we take away those rights by way of a mere circular?
Mr. Arbitrator, you should note that though under contract,
I want you to address Mr. Sekal on that. Can a circular take away a contractual right?
it cannot, but it could modulate or define. It's used as a persuasive authority here, Mr. Arbitrator.
Can it be persuasive enough to take away the rights of that accrue to a party under contract?
No, Mr. Arbitrator.
So why are you telling us to, based on a circular, to be persuaded to take away someone's rights?
Look, Mr. Arbitrator, it's a preliminary. I haven't finished with my thought process, Mr. Arbitrator. if you would permit me finish.
And then before you finish, I also want you to address me on if you said if they are required to upload their documents,
Yes.
but these category 4 clubs, which are largely in the southern hemisphere, that may not be as technologically advanced as those in the north. So if you have a club living in a low developing country, and like the applicants told us, there is a flood, there is a war, there is a natural calamity, or even they don't have the tools to upload whatever you want them to upload, does that mean that those clubs in developing countries should go without their training compensation?
No, Mr. Arbitrator.
What do we do?
There are provisions for that the association of the club should write to the notice of FIFA noting these specific circumstances.
How do they write? Someone probably, let's say it's a club in the Central Democratic Republic of Congo, deep in the rainforest. Their player has been sold out to a club in category 1. They have no internet infrastructure. They have no network gadgets. How do they write to the FIFA secretariat?
Well, Mr. Arbitrator, I do not properly understand the circumstances properly concerning this. However, a probable solution would be to communicate their concerns through the association. For example, if it's in Nigeria, the Nigerian Football Federation, which will be able to now communicate it to the FIFA secretariat.
And if they don't, do we take away their rights to training compensation?
No, Mr. Arbitrator, it
exactly.
doesn't.
So now, if their failure does not take away their right to training compensation, why don't you consider and give them their training compensation?
Oh, that is what we are arguing, that their compensation should be given to them. Lekki FC compensation should be given to them. And further, I would like to quote this authority in KRC Gen versus Lux Lille Metropole. The onus of claiming exemption from training compensation is borne by he who claims that there is an exemption to the TC waiver. So in this case, in this instant case, Bruges bears that burden and not Lekki FC or or clubs from less developed countries. Did I answer that, Mr. Arbitrator?
All right then.
Thank you, Mr. Arbitrator. Any more concerns, Mr. Arbitrator?
Fair enough. Let us hear from your co-counsel.
Okay, Mr. Arbitrator, can you give me more time, a bit, like 5 minutes to finish my argument while I hand over to my co-counsel?
No, just 1 minute.
Oh, thank you, Mr. Arbitrator. Now, without an upload of a waiver, Club Brugge cannot claim exemption from paying training compensation. This is in fact from KRC Gen versus Los Lille Metropole, which states that a club claiming exemption from training compensation bears the burden of demonstrating compliance with FIFA procedural and documentation requirements, which Brugge KV has failed to do. They have failed to be compliant with stated FIFA statutes and regulations. Going further, the appellant invokes the principle of good faith, a general principle of law that requires parties to act with honesty and transparency, which Brugge fails on its own. And this is supported in the case of Besiktas JK versus UEFA, which is rightly cited in our memorial, which supports the assertion that parties must exercise good faith in administrative matters related to compliance, which Brugge KV has failed. Thus, in conclusion, we pray that this honorable court grants the respondent their compensation, and without granting it, it is tantamount to reaping that Brugge getting away with this is tantamount to reaping where one did not sow. And if the waivers they claim to be the seeds fell on stony soil, which implies not following due process. Thank you. I'll leave proceedings to my co-counsel. Thank you.
As your co-counsel comes in, I want him to come in while answering this question. If clubs reach an understanding, they reach an understanding that they are to waive their right to a training compensation, and then later they insist that that compensation should be paid, isn't that if CAS supported that, wouldn't that be injurious to the growth of football in level 4 countries, in that clubs in level 1 will not be interested in working with level 4 countries, because even after they get waivers, they play tricks and just claim that they want to be paid the waivers. So I want you to respond to that.
All right. Thank you very much, Mr. Arbitrator. Mr. Arbitrator, I believe that, especially in law, when it comes to law, that we also have to look at the form in which these certain things are actually carried out in. Let's take, for instance, majorly the training compensation waiver that was even obtained from Lekki FC. We could see clearly that it was obtained from a team captain who does not have the local standing to even sign that any document for the club, not to even talk of a waiver, which is
We've
tending
had that.
to
My question is,
deviate their legal rights as contained in the RSTP. So
my
Yeah,
question
Mr.
yes,
is,
Mr.
Administrator.
Arbitrator.
if
Mr.
if we
Administrator.
don't if we do not, or if we let don't clubs have agreed to pay, to not to pay or to waive their rights. If CAS
Okay.
forces them, forces one to pay even if a club has waived, isn't that bad for football in developing countries? That's my question. Isn't it bad? Are we setting a bad precedent by depending on technicalities to force a club pay to pay any form of compensation just because, even if they had waived it, just because someone did not follow the rules to the dot? Isn't that bad for football in developing countries? That's my question.
Well,
Well,
no, Mr. Arbitrator, I do not believe so. Why I say so is because let's look at the pit and substance just behind this regulation. That is the payment of training compensation. We can see that the main reason behind the provision is for the development of football in these areas. So these clubs are subject to a lot of harsh treatment, and they are subject to very poor conditions. And then it's also obvious that, okay, if these clubs are not giving their training compensation, yes, there's going to be a backlash, especially on the development of upcoming players. So I believe that if these clubs are not privy to their training compensation, then it would lead to decline of football activities, especially in the development of players coming from these areas. Thank you very much, Mr. Arbitrator.
All right, then address us on issue 1 and 2.
All right, thank you very much. I'll be moving swiftly to issue 1, which is that the contract was invalid, considering that all the obligations accrued to the parties were not statutorily fulfilled. I would be basing my or tabling my arguments in two lights: one for FIFA and the second for FC Echo, Lekki FC, and Silverbird Academy. Firstly, for FIFA. By virtue of the RSTP, there are various condition precedents that ought to be met before there is a valid transfer of a player from one club to the other. One of such provisions, particularly for the transfer of international STP 2022 edition, which provides that players registered at one association may only be registered at a new one once the latter has received an ITC from the former association. The ITC shall be issued free of charge without any conditions or time limit. Another of such provisions, particularly for the signing of amateur players, is contained in Article 19, Paragraph 1 of RSTP, which has only validated players over 18 to go through the process, with the exceptions, however, contained in Paragraph 8, which provides summarily that a club owes a duty of care to the minor to safeguard him from abuse and ensure that the minor has opportunities to pursue an academic education outside of football. Another of such provisions, which one may argue to be the most important of these provisions, is for the payment of training compensation, and this is contained in Article 20 and Annex 4, Article 2, Paragraph 1 of the FIFA RSPP, which provides summarily that the TC shall be paid to a player's training club when a player first signs his contract as a professional, and each time a professional is end transferred up until the end of the calendar year of his 23rd birthday. Mr. Chairman, worthy of note is the fact that there are no express exceptions to this rule. It is thus clear from the above provisions that it's centered around the protection of these players, and reasonably so, because this cadre of players are so subject to malpractice by superior clubs or more advanced clubs looking to sign them. And let's look at the pit and substance behind this rationale by FIFA and even the Court of Arbitration for Sport in a plethora of cases. But I will be basing my argument on the case of Panathinaikos FC and FIFA. The citations are duly provided in our brief. And it was stated in this case that the rationale behind the training compensation system is to encourage the recruitment and training of young players. Following the proceedings that have been filed before this honorable court, it is evident that Club Brugge has failed to wholly comply with all its obligations as highlighted in the RSTP for the valid acquisition of Azama, particularly the payment of training compensation. And on this note, Council seeks for disciplinary measures to be taken against Club Brugge for the lack of compliance with FIFA regulations. I'll be moving on to the second basis of this argument on merit one, which is that the validity of the signing of Azama by Club Brugge without paying training compensation for him is invalid. We submit that Club Brugge erred woefully in their statutory obligation owed to Silverbird Academy, FC Echo, and Lekki FC by virtue of Article 20 of RSTP. This provision expressly states that all the players' training compensation are entitled to it. Sorry, all the players' training clubs are entitled to a training compensation, and it's a humble submission that Club Brugge erred in the way and manner of obtaining the TC from Lekki FC, as it was simply illegal. It is basic contract under any valid contract. There must be three condition precedents that must be fulfilled. There must be an offer, there must be an acceptance, and there must be a lawful consideration. Mr. Arbitrator, uh, I am focusing on that lawful consideration. It is evident and it's cardinal to ask, as per the basic principle of consideration, that what loss has been suffered by Club Brugge to entitle them to gain a benefit from our representatives, which stems down to them foregoing their legal and statutory rights to their training compensation as provided for the RSTP. It is evident and clear that this condition has been left unfulfilled by Club Brugge in respect to their phony contract with Silverbird Academy and Lekki FC. And council wishes to bring to light that the only consideration that was furnished by Club Brugge was for the benefit of FC Echo alone. Yes.
So we've
Yes,
heard
Mr.
you on that.
Arbitrator.
I want you to address the arbitral tribunal on the issue of jurisdiction, as to whether this is the right place that the applicants have brought this matter to. Is this are they in the right place? Are they in the right place?
Hello, Mr. Arbitrator.
Yes, I can hear you. I cannot see you.
Hello,
But
Mr.
the question
Arbitrator.
is, I can hear you. You can stay without your video on for network. But are they in the right place? Have they brought this matter before the right forum? Public counsel can help us. Can respond to that in a minute.
Yeah, Mr. Arbitrator, please, can you reiterate the question again? I apologize.
The question I want to be addressed on is whether this application has been brought to the correct forum? Should it be before CAS?
Yes, I think it was brought before the right forum. Certainly.
Okay. Number two, why do you think it's before the right forum?
So,
Why do you think it's before the right forum?
um, I think it's before the right forum. One, because the club is related to an association, which is related to FIFA, and also in FIFA statutes and rules, it is defined that when persons are dissatisfied with decisions being made by a secretariat, that it could be moved to CAS.
Okay. Lastly, I also want you to address the tribunal on the amounts that were calculated. Do you think they're accurate amounts?
I do think they are accurate amounts, seeming that they are coming from the FIFA secretariat, which have better knowledge and understanding and application of the statutes and rules.
Is it the position that everything from the FIFA secretariat is general truth? If something is coming from the secretariat, then we take it that it's general truth. We can't challenge it.
Come again. Could that be expanded more, explained better?
Should we say, because I've asked you whether the amounts accurate, then you said we should take them as accurate because they are from the FIFA secretariat. So my question is, should we say that whatever the secretariat says is the truth?
Well, I would apologies, there was an interruption at my end. I would say not everything coming from the FIFA secretariat is binding or true. However, if it follows and is in alignment with the provisions of FIFA statutes and other rules and provision, it is certainly binding.
So the sums, in our facts, are they in line with the FIFA RSTP?
Yes.
All right, then. The applicants, I want, when your 2 minutes rebuttal, I want also you to address me on that. But for now, respondents close in a minute. Just close your submissions in a minute.
All right. Thank you very much, Mr. Arbitrator. So I would be moving swiftly to my second merit, which is that the training compensation waivers obtained by Club Brugge are invalid and unenforceable. We contend that the training compensation waivers obtained by Club Brugge are invalid and unenforceable under the FIFA RSTP, as established that Mr. Arbitrator, and according to Article 20 and Annex 4 of the FIFA RSTP. Furthermore, FIFA has established strict procedural rules that ought to be followed for the transfer and signing of players, and it is evidently clear as per the proceedings that have been filed before us that Club Brugge has failed woefully in its application or in its Mr. Arbitrator, in their following of these provisions, particularly that of the TMS and even the electronic player passport. I am certain that
10 seconds
Council
to close.
wishes to argue under the invalid waivers in three lights. That is, will be basing it on that the argument for FC Echo with Lekki FC and Silver Bell Academy.
All right, then.
Under that
We'll close
Lekki
it
FC,
at
a team
that
captain
for
lacks the
respondents.
local standing to even sign documents on behalf of a club, not to talk of a document which purports to out the statutory rights of a club.
Respondent, that is it for you. That is all that we have
Council
for
to
you.
submit.
Yes. So applicants, you have 2 minutes to respond, but start by addressing me as to whether the figures in our facts are the accurate figures that should be payable if the tribunal finds that indeed a fee should be payable. So you have 2 minutes. The applicants, are you there? The applicants seem to have frozen for a bit.
I believe they have network issues, so I do not know if you can take it from the respondent side.
The respondents have
report probably-
already addressed us on that. Probably they can just give us their closing remarks. in a
Exactly,
minute.
sir.
Yes. So respondents, any closing remarks in just a minute?
Yes, certainly, Mr. Arbitrator. We would like to respond to the appellant on issue 2, paragraph 2 in their memorial, where it states that the waiver must be respected unless proven to be fraudulent or contested. In this immediate case, we can see that it is being contested and therefore it's not binding. I beg to correct the appellant's position held in paragraph 3 of issue 2 on its brief that the team captain role is why is basing the team captain role on popular knowledge. I question, what is the basis of popular knowledge? I thought we are supposed to base this on FIFA rules and statutes. Further, in paragraph 4 of the second issue, it highlighted that in the case of Bologna FC versus CA Boca Juniors, which says that a waiver is legal when signed by an authorized representative, which begs the question, at what point was the captain of Lekki FC authorized to take that? Further, the principle of vicarious liability, which they base their argument on, as they rightly stated, is for a contract of service, which does not apply here. However, going further, vicarious liability applies when an employee acquires liability while carrying out his responsibility and not when he's on a frolic of his own. In this extant case, our immediate case, we can see that the captain of Lekki FC went on his frolic of his own. Further, the argument that it was due to unforeseen circumstances of flood and the rest comes as a surprise to me and my co-counsel, seeing that they did not outline these in their memorial, bringing into force the legal maxim, non-surprising sign interrogation, which means you cannot surprise your opponent in court, which implies that you cannot surprise your opponent in court. Therefore, my humble submissions. Thank you very much, Mr. Arbitrator.
Thank you. Probably we have the applicants back. So just address us on the issue of the figures and then give us your closing remarks.
Thank you very much, Mr. Arbitrator. We apologize for the network fee.
It is fine. You can put off your video.
We would like to proceed now with our rebuttals. Mr. Arbitrator?
You can put off your video and then close well.
All right, Mr. Arbitrator.
All right, yes.
Thank you very much, Mr. Arbitrator.
Okay, then go ahead.
Mr. Arbitrator? Having listened to the arguments of the respondents, we have 4 grounds of rebuttals in this instant case. The first deals with the misapplication of Article 718 of the Swiss Code to state that players are not representatives of the club. However, my lord, it is, Mr. Arbitrator, it is wrong to cherry pick any section of the law, as the law is not meant to be read in isolation. Article 718 of the Swiss Code provides that unless as otherwise provided, players can act as representatives of a club. Mr. Arbitrator, on the second ground of rebuttal, the respondents also misapplied the case of KRC Gen versus Lobs Metropole that they were claiming for the burden of claiming for training compensation rests on the appellant. However, in this instant case, we have cited the case of FK Sarajevo versus KBC Westerly to prove that 4 conditions must be met before proving the of a waiver. And by virtue of paragraph 4, as we have earlier stated, we show that we have complied with the 4 conditions, which is that the waiver is not contrary to law, public policy, and good morals, and 2, that the waiver is
applicants are using again. Just put off your video for now. First, put off your video and then submit without the video. Okay, seem to be losing the applicants again. Okay, we may have to, I'm going to close at this point, sadly, without them finishing their submission. Let me just give them a minute to see if they can come back on, just for us to wind it up. Just give them a minute to see that whether they can come back on. All right. So applicants, I will have to leave it at that. I'll just give you feedback, and then we can. Yes, we'll just leave it at that. We'll just leave it at that for time constraints.
Mr. Arbitrator, we'll be done in the next 2 minutes. Can we please get an extension of the time?
Okay, just a minute. Don't put your video on. Just leave it. Just leave the microphone on and submit like that.
Thank you very much, Mr. Arbitrator. On the third ground of our rebuttal, the respondents misapplied the provisions of the FCHR that the waivers are not enforceable because they were not uploaded. Mr. Arbitrator, a careful perusal of Article 10, paragraph 5 of the FCHR shows that if a timely appeal is submitted before the CAS, it has the effect to suspend the electronic player passport process, as well as the collection of allocation statements during the proceedings before the CAS. Therefore, if the waiver is uploaded within this period, it would have the same effect like it would have if it was uploaded earlier. Mr. Arbitrator, also,
just close in 1 minute.
On the first ground of
just 1 minute to close. All right, we'll have to leave it at that, unfortunately, because of the poor network. Appellants will have to leave it at that. Applicants, just mute your mic. Just mute your mic, applicants. Okay, so I will have to leave at that, but at least we've gotten the gist of your response. Sorry that the network could not let us close off well, but summarily, you've been very good teams. you've been able to juxtapose the law with the facts, which is very impressive. And I would want to encourage you to interest yourselves more in this part of the law. It's a growing part. It's a niche. There's not many people who have gone before us. Not many people who have gone before you, and there are many athletes that the continent is producing. I mean, not all of these athletes have a good representation. Many of them end up being represented very expensively by lawyers off the continent. You saw Benjamin Mendy's decision came out just this week. He may be French, but he's originated from this continent. But you saw the lawyers that had to bring in very expensively because we didn't have these professions available to us. But it's very good to see you guys putting in the effort to appreciate this nuance in the law, which is profitable, which is very open. There are very many opportunities that are available for the taking, and all you have to do is make yourself better and better. And what I've seen today is very, very encouraging, and I bet you'll be rewarded at the end of the day. It's very good to specialize and very good to have knowledge in these special areas that will give you an opportunity to practice across the borders. When you're in this space, one of those places where you don't need the practicing certificate of Kenya to practice sports law in Kenya. You don't need one of South Africa to do sports law in South Africa. You don't need to any extra qualifications to represent someone at CAF, which Nigerian recently had a case with that you might have known of with Libya, at CAS, at various sports disciplines, at in tennis, Formula One, the World Rally Championships that are also coming onto this country, in basketball. All these opportunities are available for the taking. And what we have to do is only to skill up ourselves, interest ourselves in these areas, and make ourselves experts. No one has gone very much far beyond us across anywhere in the globe. You can practice anywhere. Today you may be with a club in South America, tomorrow you're in Eastern Europe, you're in London, you're in the Middle East, you're in Southeast Asia. Anything can happen. And I want you to encourage you to continue doing this, especially for the sportsmen and the sportswomen on this continent that badly need these services. I've been in several proceedings where many of these sportsmen from the continent just get banned without being even properly represented in anti-doping. There is floating immigration rules, taking away players' visas or passports, money transfers, how do the players transfer salaries? You're being paid in Slovenia. How do you bring that money back in South Africa? Who's there to advise them? Or who's there to tell them what to do? If you're playing, let's say you're playing in in Iraq, but you're being paid and you want to send your money back in Nigeria, how is a tax man in Iraq and Nigeria dealing with you? No one's there to advise our colleagues. Many of them in Eastern Europe and in Asia, in the Middle East. So it's very encouraging to see you guys, and you've done pretty well. I'll share your results with the FLAM, and they should be able to get back to you. But from my end, I'm very, very pleased with what I've seen, and I wish you good luck.
Thank you very much, Mr. Arbitrator.
Thank you very much, Mr. Arbitrator.
All right, welcome back to the organizers. Organizers,
thank you, everyone. We'll be getting back to everybody by tomorrow. Every single team will know their results by the end of before the end of tomorrow. Every single team will have their results ready. And thank you for being available. And God bless you. You'll be getting your result by tomorrow. Thank you.